our focus today is really the claims process and specifically how to properly and effectively contest claims. But again, let's spend a little bit of time on the initial eligibility issue. So as a general matter, someone who's unemployed and whose employment ended and remains unemployed is going to be eligible for benefits under New York law, subject to certain provisions that they were employed for a sufficient period of time, their employment ended under non-disqualifying circumstances. We'll spend some time today explaining what those disqualifying circumstances may be under the law. The individual is available for work and capable of performing work and is actively seeking employment. These aren't often contested issues themselves. We don't see a lot of that in our practice, and my guess is on your end, it's not often issues that are in play either. But again, important to have this background to really understand the rest of the process. As a general notion, benefits are made available for those who have lost their employment due to no fault of their own. That's the general notion. In reality, it is much more nuanced and complex when handling these claims. In terms of the individual being available for work, the claimant has to be ready, willing, and able to work, and they have to be actively seeking employment for which they are reasonably fit to perform based on their training or experience. In order to be considered capable of performing work, the claimant must be both physically and mentally able to perform work in their usual field of employment or perform any other work that the claimant is reasonably fit to perform by training and experience. And to be actively seeking employment, a claimant must be engaged in a very detailed and sustained effort to find work by doing things such as searching and applying for employment opportunities, working with a job placement agency, or participating with a reemployment program through the New York State Department of Labor. And just to note, a claimant can be disqualified from receiving benefits if he or she refuses to accept an offer of employment that the claimant is reasonably fit to perform by training and experience. But again, generally these are not fruitful grounds to contest a claim, but still good points to keep in mind. Ty, you want to talk a little bit about the impact of severance or dismissal plans, some recent developments in the law here.
Yes, so here, this is something to consider when drafting a separation agreement or negotiating a separation agreement. If you're going to give severance or dismissal pay to an employee, if that severance pay is over $425 per week, they're not going to be eligible at all for unemployment insurance benefits. And also, if you structure that severance payment as a lump sum, the Department of Labor employs a formula where they use the former employee's prior actual or average weekly pay to determine the number of weeks that this person will be ineligible for unemployment insurance benefits. So in practice, this means if the employee was paid $1,000 per week prior to being terminated, and you gave the employee a one-time $5,000 severance payment, the employee would not be able to receive UI benefits for 5 weeks. So what they do is they take $5,000 divided by the $1,000 they earned in the weekly wages, and that equals 5 weeks. So this is, again, something to think about when structuring severance payments. And an important exception to note is that if you wait 30 days after an employee is fired to start the severance payments, it's interesting that in the law, the employee can still collect unemployment insurance benefits and they're eligible. So again, if you want your employee to be able to collect unemployment insurance benefits, you may want to use this as a bargaining chip. You can wait until the 31st day, and no matter how much money you pay them in severance, they're still going to be eligible for unemployment insurance. So,
yeah, it's a great point. Again, this is something new, and I think it bears noting that even if you're not entering into a formal separation agreement with an employee, but you're still paying them severance, perhaps as a matter of policy or just practice, this issue can still come up. Depending on the circumstances, you might want to have a conversation with the employee. Certainly if the practice is going to be that the severance will commence immediately upon separation of employment, you might want to have a conversation with the employee just so they're aware and there's no surprises that this receipt of severance could impact their employment, or excuse me, their eligibility for unemployment insurance. And again, what it's going to do is just delay their receipt of that until the severance period runs out generally. Also, just a practice point to remember, you can't have employees waive their rights to unemployment insurance through a separation agreement. We don't tend to see that a lot, but I think it's worth noting here. What we do commonly see are provisions where an employer will agree not to contest an individual's unemployment insurance claim. And nothing wrong with that. Again, that can be part of a negotiation under a separation agreement. But I think the other point to keep in mind and remember is that, and perhaps include some language in your separation agreement to make clear that the ultimate determination of whether or not an individual is going to receive benefit rests with the Department of Labor, and further, there may be an obligation on the part of the employer to cooperate with that process and respond to inquiries. So I don't want to spend a ton of time on the specifics for how an individual qualifies for benefits. There's a lot of information on the New York State Department of Labor's website that really goes through in detail how you make these calculations. We want to spare you that. I think it breaks down to two things. How long have they worked? Did they work enough during a prior 4-quarter period of time? And did they earn enough money during that time? It's not a lot that they generally need to earn during those quarters. So again, this isn't an issue that we see come up a whole lot in terms of grounds for disqualifying somebody. As a practical tip, generally when a claim is filed, you'll get a notice of that and potential charges, and it will include the income that is reported by the claimant employee. And just make sure that information generally tends to be pretty accurate, but not always. So make sure you take a look at that information, and if it needs to be corrected, you go ahead and do that.
So now we're going to jump into the actual grounds for disqualification, which is kind of the heart of this presentation. And the claimant may be disqualified from receiving unemployment benefits if his employment ended under any of these following circumstances. We're going to walk you through these 4 circumstances and some examples. The first here is voluntary separation, then misconduct, and then refusal of employment, and then criminal activity, which is a little bit complex, and we'll walk through that. So, Andy, you can go ahead with the voluntary separation.
Sure. So we see this issue come up in our practice, not as much as misconduct, which we'll cover, but with some frequency. Employees who resign their employment without good cause are going to be deemed ineligible for benefits. Some examples of what is good cause for an employee to leave are, you can really come up with a number of scenarios. I think one prototypical example is where you have an employee who has been subjected to persistent harassment in the workplace. The employee has brought that harassment to the employer's attention, but it has still persisted without sufficient remedial efforts being made, and the employee at some point resigns, right, and lays out that fact pattern there. And that's one where I think an unemployment insurance judge is going to look at that and say, yeah, we think there was good cause for that individual to resign their employment, and therefore we're not going to deem them ineligible for benefits. If you've got a situation where there is repeated promises to provide someone with a raise, and those promises remain unfulfilled over a longer period of time, and where additional duties have been imposed on the employee, that could be a situation where the employee could walk away and resign and still receive benefits. On the other hand, denying an employee's request for a raise and the employee then quitting after that request is denied by the employer, well, that's not going to, in all likelihood, be deemed a good cause for them to have resigned, and it would be a legitimate basis to deny the individual eligibility for unemployment insurance benefits. The other category where it can be a good cause for an employee to resign and therefore allow them to receive unemployment insurance benefits is where there's some kind of compelling family reason. Some of those make sense that are on there. You also see the relocation of a spouse. There's a lot of cases on this particular subject. I think on one end of the spectrum, you could have a situation where the spouse just voluntarily took a new job in another area, and your employee is following them to that area, really for no reason other than the spouse took the job there. And in that situation, I think there's a good chance that the resignation would not be with good cause. On the other hand, if let's say there is some type of special medical need of a child or dependent that the employee provides, and therefore when the spouse takes a new job in another area, the employee needs to also move in order to attend to those medical issues. Well, then we're getting, I think, closer to the realm where that could be deemed good cause and the employee would be eligible for benefits. So misconduct. When an employee, and if an employee commits misconduct in the workplace based on his or her actions, that will be and is a basis to disqualify that individual from receiving benefits. I think the key point here is to understand that the term misconduct has a very special and very particular meaning under the unemployment insurance law. Not every issue or misdeed on the part of an employee, albeit warranting discipline and even termination of employment, may not rise to the level of misconduct to therefore disqualify the individual from receiving benefits. And I think it's fair to say, for those of you who have been in the trenches, so to speak, in handling these cases, I think we've seen the Unemployment Insurance Division, the ALJs, and the Unemployment Insurance Board, Appeal Board, raising the bar, so to speak, in terms of what they're going to deem is disqualifying misconduct. So you see some examples here that may constitute disqualifying misconduct. I don't want to go through each and every one of them, and I think it's also to keep in mind that every case is different. The rule of thumb that I've always operated under is you really have two categories of offenses that may constitute misconduct. Certain what I would call cardinal offenses that in and of themselves warrant a finding of misconduct. Theft, I think, clear instance of theft would rise to that level. And then you've got the other categories where it's an offense which isn't in and of itself so flagrant, but nonetheless is a situation where the employee was on notice that if they committed that offense, their job would be in jeopardy. Ideally, where perhaps something similar happened in the prior instance, they received a clear final warning about that. The same thing happens again, and then they're separated. I think that would be a good fact pattern to line up for demonstrating misconduct. And I think the other key takeaway here is you can have very good grounds for the termination and a very good grounds to demonstrate misconduct to disqualify someone from receiving unemployment insurance. But at the end of the day, you need to prove it, and you need to have good documentation and good proof to offer to demonstrate that, both at the initial determination phase and if you proceed to hearing before an administrative law judge. Just a quick note too on the issue of policy violations. Tyler, I know you've handled cases like that before. I have too. These can be tough cases. I think we tend to see, certainly at the hearing level, the judges really focusing on the policy language itself and wanting to see a few things. One, a very clear provision that is unambiguous and addresses the conduct in question. Two, that the employee received notice of that policy, and ideally we've got some kind of documentation, a signature acknowledgement that they received, let's say an employee handbook that contained that policy, or some form of training on that issue too. But even there, it can be tough on a policy case to ultimately prevail.
Right, and on that policy case, you wanted the policy to specifically say that a violation of this policy could result in termination, and in an ideal world, you actually would want some kind of final last notice. Those are the strongest cases before the Unemployment Insurance Appeal Board. Is you have a signed document that says, if this happens one more time, I will be terminated. Those are the strongest cases across the board. So now I'm going to move on here to disqualification for criminal activity. Again, for many of you, if you have an employee that's engaged in criminal activity, your first thought is probably not, will this individual be eligible for unemployment insurance benefits? But it is something to consider. And under the unemployment insurance law, the statute specifically provides that an employee will be disqualified from receiving benefits because he committed a felony in connection with employment. And the important thing to understand here is that while it says a felony in connection with employment, which seems to be, it would be limiting to something that actually occurred while the employee was on work time, that is actually not the case. So the first example, some clear examples of felony in connection with employment are those examples where the employee is on the job. So for example, maybe you have a bus driver that commits vehicular homicide at work. Clearly, this person is terminated. They're not getting unemployment insurance benefits. Similarly, if somebody steals money out of a safe, commits grand larceny while on the employee's premises, they're not collecting unemployment insurance benefits. But also, if this employee, say you have a bookkeeper, somebody who deals with finance, they commit grand larceny completely separate and apart from your employment. It's off the job. That goes to the heart of their employment duties, and you can terminate that individual, and you should be terminating that individual, and they would not be able to collect unemployment insurance benefits. So the law is a little bit complex in this area when it gets down to misdemeanors, so I'm not going to get into that in too much detail. What I do want to say is that most and many felonies are going to result in disqualifying conduct across the board. Misdemeanors are going to require a very careful analysis. But I want you to also consider that any time an employee has an arrest or conviction, you'll have to consider the human rights law as well. So just, again, keep the human rights law and unemployment insurance law in mind when making these determinations. And that covers the criminal activity portion.
No, I think it's a great final point, Tyler. And as I suspect many of you are aware, we have a couple statutes in New York. First, Article 23A of the Corrections Law, which is then also incorporated by reference into New York's human rights law, which, as a general matter, prohibits the taking adverse employment action against an individual based on their prior criminal history or conviction, unless, and this is an oversimplification, but unless that would pose an undue risk of harm, and there's a sufficient nexus between the duties of the individual and the criminal offense in question. And what you need to do, again in a nutshell, is to weigh a number of factors that are set forth in Article 23 of the Corrections Law, and to then analyze ultimately whether or not, based on those factors, which look at how long ago was the conviction, what was the conviction for, what are the duties of the employee, the nexus between those, and then how likely is the risk. I would just also mention that this is an area where federal regulators at the EEOC and also the New York State Division of Human Rights have taken a particular interest in and are very closely scrutinizing employment decisions based on criminal history information. So again, I guess our takeaway is just proceed carefully when considering termination based on someone's criminal activity. All right, so I suspect that many of you have been through or at least generally familiar with unemployment insurance claims and how the process works. We'll cover this just very quickly, spending a couple minutes, and then we obviously want to get into some strategies for contesting claims at the initial determination phase and especially at the ALJ hearing phase. In terms of the process, it's pretty simple. Employee files a claim after employment separation. They usually do this online. They'll answer a bunch of questions, including questions on how their employment ended. The employer then receives notice of that claim and is given the opportunity to file a response. They are required to do so before a specific date. And the law here was recently changed that it creates some penalties if the employer fails to do so. And if an employer doesn't respond timely to the request for information and there's a subsequent determination made that the individual was not eligible for benefits, the employer is not going to receive a credit or an offset based on charges to its account for those benefits that were paid. So again, keep that in mind if you're going to contest a claim. The New York State Department of Labor will then issue an initial determination based on the information that it received. If either party disagrees with that, then they can request a hearing before an administrative law judge, and they generally may need to do that within 30 days. In terms of the process, it's not uncommon, even where a case is adversely decided against the employee, that it ends with that initial determination. So it can be worthwhile for purposes of contesting to invest in that initial process. The threshold decision, should we contest a claim or should we not contest a claim? I think it's going to depend on a number of factors. First and foremost, how strong a case do you have? Was it one of those cardinal offenses? And what's your proof? How strong is the proof that you have there? How are your witnesses? Do you have strong witnesses that will be able to demonstrate that the misconduct occurred? Do we need to have legal representation for purposes of the case? Not always, I guess here one takeaway, and this falls under the category of considering other motivating factors, is that contesting these cases isn't always about winning these cases. There can be other motivations on why you may want to contest an unemployment insurance claim. Let's say in particular, if you're concerned about another claim, let's say a harassment or discrimination claim that's either been filed or threatened, contesting an unemployment insurance claim on the merits can also give you an opportunity to assess the claimant's credibility and abilities as a witness. Do they make a good witness? And also provide you with an opportunity to gather up some more information about the claimant and those other potential claims that are out there. I think it is important to remember, too, that whatever you submit to the Department of Labor is going to go into the unemployment insurance file, and the claimant is going to have an opportunity to review that information, too. So after the initial determination, you've made a decision to contest, or the other side has made a decision to contest the initial determination. There'll be an evidentiary hearing that's held. Parties have the right to be represented by counsel at those hearings. I think one point here to keep in mind is that a claimant may be precluded from relitigating any factual issues that were decided previously in a disciplinary proceeding. For example, if there was an arbitration that was held and the arbitrator made certain factual findings with respect to what occurred relative to the misconduct, the employee claimant may be prohibited from trying to relitigate those issues. Based on the hearing, and we'll talk more about that, Based on the hearing, the ALJ will then issue a decision within 5 days. And usually the judges are good about turning those decisions around in fairly quick order. Sal, you want to just cover the further appeals process briefly?
Yeah, so the next step is you would go to the Unemployment Insurance Appeal Board, and what that process looks like is you are going to file a notice to the Unemployment Insurance Appeal Board within 20 days saying, I'm appealing this decision. You will state your grounds for appealing that decision, and then what you want to do is order and request a transcript. So you'll get a transcript of the actual, everything that happened underneath with the ALJ, you'll get a transcript, and then you'll typically write a brief based upon that transcript. And again, once you get the transcript back, you'll have 20 days to write your brief. So everything will be spelled out for you in the determination that you get from the ALJ on how to go through the appeal board process. So just pay very careful attention to everything you get from the ALJ. And then again, next step is if you're unhappy with the appeal board's decision, you're going to actually appeal to the third department. Similar to the process for the Unemployment Insurance Appeal Board, it's a process of giving them notice that you're going to be appealing. This time it's within 30 days. So give notice to the appeal board that you're appealing, and then typically you write a letter to the third department clerk as well that you're going to be appealing the decision. And then you actually have 9 months to finally, what is called is perfecting the appeal, which is you file the brief, you file your transcripts. So you have quite a bit of time to make your appeal to the third department. And then if all else fails, you lose, you can attempt to go to the Court of Appeals. The Court of Appeals is very, very hesitant to hear a lot of unemployment insurance cases because the standard for reversal is very, very difficult. So they'll typically reject appeals, but just so you know, that is the final process. You can get an unemployment case to the Court of Appeals. So now I think we're going to get into what a lot of you are here for is actually the strategies. What do I need to do? Where do I need to be in terms of my practice before to be in the best position to defend myself at the hearing? And how do I win a case?
So what we're usually doing at the hearing level is contesting a claim based on the employee's misconduct that led to the termination. Sometimes, again, as I mentioned, it'll be a case where the employee left without good cause on their own, and the hearing could focus on that. But either way, and this is the image that I have there, either way, the most important work potentially leading to a victorious unemployment insurance case is done before the claim is ever filed. And that's where it's important to lay a strong disciplinary foundation to ultimately win that unemployment insurance case down the line. And again, the case could be won or lost before that claim is ever filed. And so the key tenets to keep in mind in how to lay that strong foundation are the tenets of what we refer to as just cause discipline. And again, I'm not referring to a certain bar or level above which discipline is considered just or below which it's considered unjust or unwarranted, but rather the process that you follow leading to the discipline. And again, I can't emphasize enough that the process that you follow for issuing the discipline will ultimately be critical to the case that you lay out at the unemployment insurance hearing. The factors, there's 7 of them. We call them the 7 steps of just cause. You see them here. First, notice. I think there's a lot of focus that we see at the unemployment insurance hearings about notice. Right? Was the employee on notice that the conduct in question could lead to disciplinary action, including termination? How reasonable is that rule? What about the investigation that was conducted? Again, we see the judges focusing on this in misconduct cases. That finding of the investigation may be crucial to the unemployment case. And if that investigation was incomplete or poorly done, it can ultimately compromise the unemployment insurance defense case. And here we see the 7 other factors. Was the employer's investigation conducted fairly and objectively? The question that I see an ALJ ask almost every time about the misconduct is, did you give the employee a chance to tell their side of the story? And barring exceptional circumstances, that is always our recommended practice. It's a good one. Give the individual the chance to explain themselves, because the way this plays out in an unemployment insurance hearing is that the judge will really hone right in on that, and the judge will be very skeptical as to the motives behind the separation if the employee wasn't given the chance to explain themselves. And here's why it's a good idea too. Besides that point, there's a number of things. One, you may get an admission from the employee. This happens. It's happened to a number of clients. The employee comes out and just admits that. You've got your documentation right there of that admission. The employee might lie about it, and they might lie in such a way that you can establish that they were lying to you as part of that interview, which then provides even more stronger grounds for the separation and the contest of the unemployment insurance claim.
Right. From what I've seen, I mean, lying and blatant dishonesty is something that ALJs typically find to rise to the level. I mean, it depends on what the violation is, but we find that typically if you have clear proof that the employee is blatantly lying and being dishonest, then it's very helpful in the case.
Yep. And the other thing that I see happen is that the employee may admit to other deeds of misconduct, which again can provide additional basis for you. On the equal treatment issue, you've probably seen this, I know I have, where the claimant will say, well, yeah, I got fired for that, but I know Sue and I know Tom, and they did the same thing, and they didn't get fired, so this is unfair. The judges will sometimes focus on that issue, so I think you need to be prepared to at least offer testimony and perhaps have some documentation showing, no, we've treated this issue consistently in the past and did so again with respect to the claimant. All right, so with respect to the initial determination phase, what does your contest typically entail? Well, you'll get the notice of the claim, and then you'll have the opportunity to file a notice of protest with the Department of Labor. Depending on what you submit in the notice of protest or what the employee submits along with their claim and the answers that they provide, that can then automatically trigger some additional questions from the Unemployment Insurance Division. They'll send you a form and these questions that they'll ask you to complete, and or an investigator from the Liabilities and Determination section will contact you and ask you to participate in a phone interview. Well, they'll try to gather that same information. Also, the receipt of that information will be taken into consideration, and ultimately an initial determination as to the individual's eligibility for benefits will be received.
I want to just highlight on that note on the bottom, I really can't be highlighted enough. If you are an employer who uses independent contractors for any part of your business, if you have some filing that potentially relates to that independent contractor, so you've classified them as independent contractor, they get fired, well, not fired wouldn't be the term, their services are ended, and they end up filing for unemployment insurance benefits, whether it's out of confusion or whether they think they're an employee. You need to know, and I would get an attorney involved in the process early, because the risk there is that if they find one of these individuals to be an employee of yours, that you had control sufficient for an employment relationship, that could then open the door up for an audit of all of your other individuals that you similarly use for independent contractors. And so this one finding against the one individual that's an independent contractor is very critical that you put your best defense forward at your first chance.
It's a great point, and hopefully most, if not all of you on the line here are keen to the fact that the issue of independent contractor classification is a significant one, and one where we're seeing some major developments and very, very close scrutiny by workplace regulators on the federal and state level. And this can come up again, in a number of different circumstances. It can come up in a situation where the service provider herself is very satisfied that she's an independent contractor and prefers that relationship. It may come up in a situation where the worker has to string together a bunch of different work opportunities in order to qualify and have demonstrate the sufficient earnings. So all of a sudden, the compensation that the individual received from your organization gets lumped in with this, which then triggers a couple different things potentially. You may get this seemingly strange questionnaire from the Department of Labor that focuses on this individual's duties and what did they perform with you? Was there any written agreement with them? I think when you get that, that's a good point to just pump the brakes, take a close look, and potentially engage counsel. To Tyler's point, what you may also see is an audit that somehow this claim, and you may not get notice of that claim either from this particular contingent worker, but that is triggered an unemployment insurance audit, and you'll get a request for a ton of records, and payroll records, disbursement records, corporate meeting minutes, etc. And the purpose, usually, not always, but usually the purpose of that is they want to look at who are you paying and how are you paying them, and to try to identify any disbursements that look like you're paying it to individuals and not as employees. All right, so some recommendations for the initial determination phase. Well, of course, be timely. Make sure you provide that information back to the Unemployment Insurance Division in a timely manner. Be prepared. Have the documentation that will corroborate and demonstrate your point that the individual committed misconduct. And again, in the don'ts here, I say don't overshare. Try to keep it as simple and certainly accurate, but keep it as simple as possible. You don't need to provide a litany of the individual's entire performance issues, but give the investigator enough to have them be comfortable that this individual committed misconduct. And here's just a tip I think that perhaps not too many people are aware of. It is common that you can get what appears to be a very bizarre determination from the Unemployment Insurance Division. You might think you have the clearest case possible of misconduct based on your experiences, and you may well have that case, but yet you get a decision indicating that the individual is qualified for benefits. And further, you look at the rationale for why that individual got benefits, and it's demonstrably wrong. Right? You have proof to show that this individual should not be qualified, and perhaps it's proof that didn't get submitted on the front end. So now you're inclined to further contest the matter. When you do so and you request the hearing, don't be afraid to attach some additional information or to address what you feel is the error that was made as part of that initial determination. What can happen, and what we've seen happen in multiple instances, is somebody at the Department of Labor, when they get that hearing request, will actually look at that document and look at the documentation that you're providing, and they may issue a new determination disqualifying the individual from benefits. So there's an opportunity there for you, short of the hearing, to perhaps achieve a more favorable result. Try to take advantage of that if you have the right facts. In terms of the hearing phase, well, it involves a number of things typically. You're generally not going to have a ton of advance notice. Sometimes you have a couple weeks. Sometimes you have as little as a few days, unfortunately. So try to be ready beforehand, knowing that you're going to contest the claim and you're going to go to a hearing. Don't rely on having a ton of advance notice. The testimony that's given will be under oath. There'll be examination and cross-examination of witnesses. And here, an unusual element of unemployment insurance hearings is that the judge will actually do the bulk of the questioning of witnesses. And usually, if it's attorneys there, the attorneys do the questioning, and the judge sit there, weigh things, and address his points of law if need be. So it's unusual, and keep that in mind. Pay attention to the questions that the judge asks, and don't cover that same ground. But if you think the judge is missing something, make a note of that so that you can then circle back on that issue and get the judge up to speed on what you think are the facts that were missed there. You want to have documents ready that demonstrate your case, and that those documents will be introduced as evidence. The proceedings recorded, whether it's in person or by phone, there's a tape recording of it. And a common feature is that there's going to be time constraints that you're under. And you may perceive those, and you may get a sense that the judge is really moving this along, because typically they'll have a number of hearings scheduled on that same day, and you've got a very short amount of time to get the case in and get the hearing done. And ultimately, this will lead to a decision from the administrative law judge. In terms of the recommendations, be prepared, right? That's always the best practice. And one of the first questions that you're going to get asked from the judge when you're there as the employer's representative is about some basic information about the claimant. When did they start to work for you? When did their employment end? What was their pay rate at the time? What was the reason that they were terminated? And then to start into the why.
Right, because I mean, you may already be a little bit on edge going into that hearing, and then they ask those questions, and you aren't prepared with that information, then you get completely thrown off for the rest of the hearing. So just having that basic information prepared puts you in a good frame of mind for getting into the hearing.
Have your exhibits ready. In those exhibits, the documents, the termination letter, let's say an investigatory finding or a witness statement, have those documents ready and have copies. One copy for you, a copy for the judge, and a copy for the other side. Have your witnesses ready and prepared. This can be a pretty scary experience if you're going to pull in a rank and file employee witness for them, and you're going to want to talk to them before and have them understand the process. Have them understand what they're going to be going through, that although it is an informal procedure, there is a judge, there is testimony under oath. You're going to be in a small room around a small table, and the claimant's going to be on the other side of that table, so that they're prepared. You want to talk to them about listening to the questions that are asked by the judge or by the other side or by you, and answer just those questions, and of course do so truthfully. That they stay calm. These can be contentious proceedings, but you want to make sure your witnesses understand the need to stay calm, and of course that they dress appropriately. Standard issue employee wear might be t-shirt and jeans, but we want to dress better than that for purposes of the hearing, so that we make the appropriate presentation. You want to be courteous. Yes, judge. No, judge. Thank you, judge. You want to use Mr. and Mrs. Always be courteous in the course of that. You want to be strategic. You want to get in and out of there as quickly as possible. You want to give some thought to who should I call first as a witness? Who should I maybe not call because they're not a good witness? What kind of documents should I bring in beforehand? You want to stay composed. These can be very contentious hearings where there's hard feelings on the other side. You want to be the person who stays calm and composed throughout the proceeding. Let the claimant be the one who gets worked up, not you. And then also, you'll be provided an opportunity to make a closing statement. And I would have one in the can ready to go before. It's a great way. Having that closing statement ready is a great way to really focus on your case and what it's all about. And I think it'll get you thinking, what do I need to get in terms of my proof here? And also a tip I think that some aren't aware is you can access that unemployment insurance file. Right? There's a file that consists of everything that the claimant submitted and everything that you submitted as part of the initial determination and as part of the request for hearing. It can be a tremendously helpful source of information because there'll be a transcript of what information the claimant disclosed, let's say as part of a telephone inquiry with the investigator. There'll be the information that they disclosed when they applied for benefits initially. There can be some great admissions in there that you can use at the hearing against the employee. There may be blatant instances of dishonesty or falsehoods in the information that you can establish and use to go after the credibility of the claimant. And moreover, it'll help you understand what the employee's theory is on why they should be eligible for benefits. And it's not always clear through the initial determination process. So in terms of the don'ts, don't be late, be early. It's not a two-way street here. And they'll give the claimants some flexibility in getting there, and they're not always going to give the employer and the employer's representative the same amount of time. I can tell you some stories that I've heard where an employer representative shows up with their witnesses 2 minutes late, and the judge doesn't let the hearing go forward and issues a determination in favor of the claimant. Be there on time, be there plenty early so that you're ready. And that can be a great time too. If you get there a half hour early, that can be a great time to take a look at the unemployment insurance file too, if you can't get down there beforehand. Don't assume that the ALJ knows anything about your case at all. That's for two reasons. One, they can't consider anything as being in evidence that was already submitted as part of the initial determination process. So you need to get all that evidence in that demonstrates the misconduct or the other basis to disqualify the individual. The second reason is that, again, the judges have a number of hearings that are scheduled back-to-back, and their days can be very, very full and busy. So they may not have had time to get fully up to speed on the case and the history of it. Tal, you wanted to mention a little bit of your experiences with first-hand witnesses too, right?
Yeah, I mean, so certain cases, you have a witness who's going to be out of town, can't show up, or is just uncomfortable showing up. That's really the issue that I had. It was an employee who really was not comfortable coming to present at the hearing. And this employee would have been able to present very, very clear evidence and testimony that the claimant was blatantly lying about the circumstances relating to the termination. But the rule is generally that the unemployment insurance ALJ will accept hearsay testimony, so that's testimony from a third-hand source. But if they have somebody there, a first-hand witness, they have to trust the first-hand witness who is testifying over that hearsay testimony. So again, you want to focus in and get those people who have first-hand knowledge of the facts, because again, if they have the first-hand knowledge of the facts and they can testify and disprove the claimant, they're going to be the ones who are trusted. But if you only have the claimant's testimony and you don't have anybody else with first-hand knowledge, unfortunately, they'll have to rely on the claimant's testimony.
Right, so you have an HR representative, right, who supervised the investigation, talked to witnesses, including first-hand witnesses, gathered up that information and perhaps some other documentation and made the determination, all right, yeah, this misconduct occurred, and then was involved in the decision to terminate the individual. Certainly, the testimony from that HR representative will be important to the case, but I guess our point here is don't think that that's enough necessarily, that you're going to want to bring that witness to who actually saw the conduct that occurred so that you've got that first-hand testimony. Because what's the claimant going to do? Well, you know, in the rare case, maybe you've got a prior admission that you can use, but they're going to deny it too at that hearing and say, oh, that never happened, I never did that, they're wrong. So you want to have first-hand witness testimony, if at all possible, there to offer your proof. And another point, don't feel, sometimes you can get lulled into thinking that the judge is seeing things your way because of the questions that the judge is being asked, or you may think the judge is getting frustrated with the claimant. Don't rest alone on that fact and that belief. You may be right and ultimately may prevail on that basis, but don't rely on that in lieu of getting the evidence in that you need to demonstrate the disqualifying condition exists.
And I think it's just critical to reiterate that the only evidence that the ALJ can consider is that evidence that is presented on that day. Nothing in the file from beforehand. Just on that day, what you have presented as evidence is the only thing. Those are the only things that can be considered.
All right, so let's very quickly talk about a few complex issues that can come up. First, what if I get the hearing date, it's 2 days from now, I can't go, or I've got a key witness who can't go, what do I do there? Well, a couple different things can happen. If you've requested the hearing and can't appear, then what may happen is that the judge will sustain the initial determination that was made, right? You requested the hearing, so it was adverse to you. The judge will sustain the initial determination, and you can then request to reopen the case at a time that works for you and when your witnesses can be there. And generally, they're pretty receptive. You've got to show good cause to support that request for reopening. But if in advance you've let the judge know that, hey, we can't appear on this date because of XYZ reasons, we request an adjournment, get that on the record before the hearing date and get that to the Unemployment Insurance Division so that you build your case later to request the reopening. If it's the claimant that's requested the hearing, so in other words, you prevailed at the initial determination, you got the hearing notice, you can't appear at that date, what generally will happen is that the ALJ will proceed with the case without you being present. And I've had instances where the employers weren't able to attend, and the ALJ interviewed the claimant and still found against the claimant. If, on the other hand, it's an adverse determination against the employer, you can also, in that situation, request to reopen, at which point you would be able to offer testimony demonstrating why the misconduct occurred. If the claimant has an attorney, I don't think there's any reason to be afraid of that in and of itself. I can tell you that judges generally aren't going to be receptive to an attorney badgering an employer's representative or treating them in a shabby manner. But on the other hand, it may warrant you seeking counsel too to have representation there. We talked a little bit about what if there's another type of claim that has either been threatened or filed against us. I think there, good advice, let's be careful, right? We don't want to provide the claimant with any more ammunition than they may already have to support those allegations, and we want to proceed carefully and use the process perhaps to our advantage. If you or a witness feels threatened by a claimant, and there's legitimate grounds for that, it's something you can bring to the attention of the judge, and maybe a phone hearing is preferred in that instance, or there's some other way you can work it out with the judge. And likewise, if the case involves discussion of confidential information, highly sensitive confidential information, give some thought to how to approach that. Now, there's some exceptions under HIPAA for when information can be shared in the course of an adversarial proceeding, but there's different ways you can practically handle this too, right? So let's say the case involves the abuse or maltreatment of a patient. Well, we don't want to have that, the identity of that patient may be an important fact, but we don't necessarily need to and shouldn't use that patient's full name, right? We could raise this issue with the judge and say we'd like to refer to the patient by their initials instead of that, and it should be perfectly clear to all the parties exactly who you're talking about in that situation. So we've got a few minutes left here, and maybe we could just take a question or two. One question we got was, well, what do you do with a grumpy judge? That does happen. I think the advice is stay calm and be thoughtful of the points that we've covered here, right? Be respectful of the other side, treat the claimant well, be calm, be courteous, and don't be redundant, I guess, is a key thing, right? If a point's been belabored by the judge and ground's been covered, don't cover it again, unless there's something key that's been missed. Tyler, any thoughts on that?
Yeah, I guess to be redundant, I mean, it's the same thing that Andy said, is these judges are very, very pressed for time. They want to get things done quick. If they hear things being repeated, they do get grumpy and quick. I mean, they're sitting in that room all day hearing case after case after case with a lot of similar issues, and they're just going to want to get things done. So just be nice, I guess, is the takeaway there.
Just be courteous, and sometimes you're just going to have to deal with it, unfortunately. But on the whole, I think those are the exceptions, and the judges try to be as thoughtful as they can, and are pretty patient for the most part. We had a question about, well, we've got somebody classified as an independent contractor. How should I respond to a request for information from the New York Department of Labor? I think that's where, again, I think let's be careful here, because this could have significant ramifications, not only for the worker in question, but others who you may also have classified as independent contractors and who are similarly situated. And what can happen, too, is this issue can cascade into a number of problems. If you have misclassified that individual and the Department of Labor takes the position that, well, they should have been an employee under the law, that can have, of course, ramifications under the unemployment insurance law with respect to your contributions that should have been made for that individual's payroll. But also, there's information sharing with the New York Workers' Compensation Board and the New York State Department of Taxation and Finance, and additional issues can raise there. So in that situation, we do recommend that you seek counsel. So we want to be cognizant of your time here. I'm sorry we couldn't get to every question that is there. We appreciate your attendance today. We hope this information has been helpful. Listen, these are tough cases. They can be tough cases to win. Make no mistakes about that. And I think those around you who may task you with these assignments, you need to let them know too that these can be tough cases. But hopefully we've provided you with some information that'll help arm you to handle that next case with confidence. We're always here if you need us.